We're going to start off with in the public law arena. Now, the case that I've chosen to do is ReBE Supervision Order 2021. Now, this is a judgment that was handed down in February of this year, so not too long ago. Now, the reason that I've chosen to do this tonight and to share it with you, because it's all about care proceedings and parents with learning disabilities. And it's a great reminder for us as practitioners, for the court, but also the judges, as to the approach that needs to be adopted in such cases. Now, what is this case all about? I'm not going to get too bogged down with the facts, but essentially this case is where we have a mum, dad, they've had a baby, the baby has been taken into care by the local authority as soon as it's been born. Mum and dad have a long-standing criminal record. Dad has used drugs, mum has emotionally unstable personality disorder, but she also has a learning disability. And there have been allegations of coercive and controlling behaviour of dad towards mum, but actually in the context of her learning disability, it's not coercive and controlling behaviour, it's actually support, which enables her to provide the basic needs for the child. So fast forward, parents have engaged with professionals, they've managed to rehab themselves to the point that the local authority are looking at the child go back into their care. The guardian decides they're opposing this, they're against it because they still think there's a real risk posed by parents to the child. So eventually what happens is the court makes a final order, and that order is a supervision order parallel with a child protection plan and a contract of written agreements. So that's the case in a nutshell. Now, what are the key points to take away? Well, there are three. The first one is don't judge a book by its cover and don't assume. You need to identify pretty quickly if you're dealing with a case where a parent has got a learning difficulty or disability, I should say. The second thing in relation to this is you need to be alert and you need to be alive to the nuanced parenting partnership if one or either both of parents have a learning disability. Because what we saw in the case earlier was perceived coercion and controlling behaviour, but actually it could be support or help to one of the parents that enables them to provide the care. Now, from a practical point of view, and as practitioners, what does this mean for you? So first and foremost, you need to modify your approach. This isn't a case similar to a case where a parent doesn't have a learning disability. Your starting point are the principles that have been outlined, but also endorsed by the former president of the Family Division in the case of ReDE. Now, I'm not going to go through those principles because we are tight on time, but they are in the handout. So I would encourage you to look through those. Now, the second key point is supervision versus care order. Care orders can be quite oppressive. In cases where you've got parents who have got learning disabilities, having a care order in place, it could be demotivating, and it can really knock their self-confidence when they have managed to rehab themselves. So I would encourage you to get creative from a practical point of view. Think of different solutions. Can you have a supervision order which has additional bolt-ons, like for example in the case we've just looked at, which manages to give the parents a bit of self-confidence, but also has the interest of the child at heart as well. My final take-home point and my third key point really is come prepared and put your money where your mouth is. And the reason I say that is because the guardian came to the court without an application, but opposed the child being subject to a supervision order. As practitioners, we must remember efficient and effective hearings. Those two words must be at the forefront of your mind. So if you are opposing something, that's absolutely fine, but make sure you've got an application which has evidence outlining why and supporting it, but also the fact that, be proactive, suggest alternatives. It's better to get knocked back by a judge than not turn up to court and not have anything there. So those are my three key points.